Hello, I'm Susan Bright. I'm a professor at Oxford University and I want to talk to you today a bit about building ownership. Well, really what I want you to do is to think about what you understand ownership to be and whether it means anything in landlord terms. And the particular focus that we're going to have is on issues in relation to blocks of flats and fire safety following Grenfell. The Grenfell Tower fire happened on the 14th of June 2017, so that's now over 3 years ago. And you may be familiar with the fact that the fire was just so terrible, in large part because of the cladding that was on the outside of the building, and that caused the fire to spread very quickly and tragically. Now, since Grenfell, hundreds and indeed thousands of other blocks of flats have turned out to be unsafe because investigations have been done and discovered that they too have fire safety issues. And relatively soon after Grenfell, the government started saying that the responsibility for fixing these blocks fell on the building owner. Now, as a landlord, I'm thinking, well, who do they mean by the building owner? So that sets the scene for why we're thinking about ownership today. What does it mean, if anything, to say in landlord terms that someone is the owner of a building? Now, there are various ways we could approach this question. The first is to see it as a theoretical question, and there's been lots of work done on property theory, and one of the most popular, or perhaps described as a paradigm, understandings of what ownership means is to see it as a bundle of rights. So within this bundle, the rights holder, the owner, will have various rights in relation to other people. So they'll have a right to be able to control the use of the property, to enjoy it, to exclude others from it, and to dispose of it. And we can think of this perhaps in the context of where you're living this year. So as a student, you're renting a room, and that gives you the right, primary right, to occupy it and to enjoy it. But we can fairly quickly see that actually you're not the only person who has rights in relation to that room. So the landlord will also have rights. The landlord will have the right to receive the income from the property, the rent that you're paying. And this illustrates one of the difficulties with the idea of ownership as we apply it to property rights and to land law in particular. So this difficulty is the first one that we're going to look at, is what happens if different people enjoy different rights to the same thing, your student room. If we're going to say that one of these two people, you the student or the landlord, is going to be referred to as the landlord, as the owner, we're presumably saying that one of the rights is more important than the other rights. How do we designate which are the more important rights to then attach the label of ownership to? But another difficulty with this approach for the bundle of rights is obviously focuses on the idea of rights, that the owner has rights in relation to the property. But shouldn't owners also have some level of responsibility? And that again is something that we need to think about as we're thinking about building safety. So let's turn now to think about this from a landlord perspective. Now in land law, in English law, we don't have a concept of ownership as such. What instead we own in English land law is an estate in the land. We talk about people holding the land for a period of time. And as you'll have learned, or you will be learning on your land law course, since 1925 there are two periods of time that can be recognised as legal estates. One is for an uncertain period, and the Walsingham's case from 1573 referred to this as being time in the land without end. And in the language of the Law of Property Act 1925, this is the fee simple absolute in possession, or perhaps more commonly referred to as the freehold. The other period of time is where the land is held for a certain period, a determinate, a known period of time. And in the language of the 1925 Act, again, this is the term of years, absolute, but more commonly is referred to as the leasehold, or indeed a tenancy. Those two terms mean the same thing, it's just that we tend to use the word tenancy for short-term arrangements and the lease for longer-term arrangements. But in land law, there is no concept of ownership as such. So let's move on now to the third perspective, looking at ownership from the point of view of everyday understandings. What do you think about ownership of land? Who do you think is the owner of any plot of land? And the reason for the image on this slide is that I think it's a rather slippery concept. It's actually quite hard to explain who we think of as the owner of land. So if you're renting a house this year as a student, or a room in a house as a student, you probably don't think of yourself as the owner of that room or that house. But why not? You do have an estate in the land if you've got a tenancy, if you have a lease. Well, probably you don't think of yourself as an owner because you're paying rent, or because you've only got it for a relatively short period of time, say 10 months or a year, or because you have very limited freedom as to how you use the room. But would that change if perhaps we gave you a longer lease, not a 10-month or a year-long lease, but perhaps a 99-year lease? Or now we said that instead of paying a rent every week or every month, what you did is you paid a large capital sum at the beginning in order to purchase the lease. So would you then be thinking that this felt more like ownership? And what is it that's changed between the arrangement that students have and perhaps the person who does pay a large amount of money to purchase a very long-term interest? Now, this is all background to help us think about the context of Grenfell and fire safety. And in relation to a block of flats, ownership can be quite complex. But so here we've got a series of diagrams which are rather simplified versions of what actually is often found on the ground. But in a block of flats, it is the freeholder who owns the building and has control of what we tend to refer to as the common parts. And by common parts, we're looking at the external structure, the stairwells, halls, lifts, car parks, perhaps gardens outside and so on. These are all the common parts of the building. Now, if we apply this to Grenfell, the freeholder at Grenfell was the local authority. It was the Royal Borough of Kensington and Chelsea. And the local authority, as did many local authorities in the 1960s and 70s, built these tower blocks in order to house their council tenants who are renting flats from the local authority. But obviously blocks of flats can also be privately owned. So we'll come on to the privately owned blocks, the private freeholders in a minute, but let's now focus on other flats within the block. So we've got some flats that are being rented by the council tenants, but you may be familiar with Margaret Thatcher, who in 1980 introduced the statutory right to buy. This gave sitting council tenants the rights to buy their flats at a substantial discount. So several flats, indeed many of the flats, were actually bought by private individuals, and these we refer to as privately owned flats. And the leaseholders who bought these flats were given 125-year leases and had to pay a rent, but only a very small rent of £10 a year. And in turn, some of these leaseholders now may be renting out these flats to tenants, their own tenants in the private sector. So going back to the idea of there being private freeholders, again, it will be the freeholder who owns the building and has direct control of the common parts, but the freeholder there may be perhaps the developer, the person who put up the block of flats, or an investor or a pension company who's bought the freehold simply to provide an investment income from the rents that are being paid, even though they're very, very small rents. Or sometimes the freeholder will actually be a company. So the freehold may be a company that is controlled by all of the leaseholders. So anyone who buys a flat in the block is also getting a share in the company that owns the freehold. So you can see that ownership of a block of flats is a rather complex idea. So this takes us back to the government's response to the problem of Grenfell and the other blocks with fire safety issues. Who should be fixing the problem? Well, should it be the leaseholders, the people who have flats in these blocks? And one argument for saying it should be is because the value of the building is largely comprised of the value of the individual flats. The shell itself, the common parts, has relatively little value. but it's the flats that collectively carry the value, and therefore the leaseholders have the most financial interest in making sure this block is made safe. But the problem then is that the leaseholders don't have any ability to do so, because the common parts, the external wall, is actually held as part of the freehold. So the leaseholders have no ability to fix the outside of the building. And of course the leaseholders didn't actually create the problem. These are people like you and me who bought a flat innocently believing it to be safe to live in, just as we might buy a car or a fridge. We assume that it's going to be safe to live in. It turns out that it's not. So the government's response, though, early on, they've slightly changed their tune since, was that building owners should, and this is to quote the phrase they frequently use, do the right thing. And by doing the right thing, they meant they should fix the problem and they should not be charging the leaseholders for it. Now, although they weren't express about this, what the government meant by building owners was usually the freeholder, although sometimes they also talked about the developer. And the developer has nothing to do necessarily with the building ownership unless they happen to also have or require the freehold. But if the government's then talking about freeholders, building owners doing the right thing and fixing it, why should the freeholder? Did the freeholder cause the problem? Well, quite possibly not. The problem was caused by the developer, perhaps the builder who didn't do things right, or maybe even by the government because the building regulation system wasn't fit for purpose. And I've already mentioned that the freehold itself may not be worth very much. So why should a freeholder have to spend millions of pounds rectifying a building when actually the value of their investment is relatively minor? And improving, making the building safe isn't going to significantly increase the value of their investment. Their investment is simply a return on the rents that they're receiving. Well, maybe it's because the government thinks that freeholders have got deeper pockets. Well, often that may be true. It's not always going to be true. Some freeholders are not worth very much financially. But in any event, that is never a good reason in other contexts for saying someone should be responsible. Simply because someone's got more money, deeper pockets, doesn't mean that they therefore should carry a responsibility. But there is a practical reason why a freeholder should fix the problem, and that's because they are the only legal person with the legal power to do so. It is the freeholder who owns the exterior of the building and the common parts, which is where the fire safety issues are going to be. So what I hope that you can see from this very brief overview of building ownership and thinking about how it applies to blocks of flats is that it's actually a really complex question. And when the government says building owners should be doing the right thing, this all sounds very appealing. It's got perhaps a morally intuitive sense of being the right response. But when we start to unpick it, we can see that it doesn't hold water. And particularly when we look at it through the lens of land law, we can see that building ownership doesn't mean very much at all. And perhaps it's like the emperor's new clothes and not really there. So what I've done in this lecture is just touch upon some of the legal issues that arose post-Grenfell and those that relate most to land law, but there are a whole host of others, and you'll see some of them are flagged up on these posts that I've put here. This is from the Housing After Grenfell blog that I host. One is about how the landlord's right to enter the flat. So this picks up on a case that you'll be reading in Land Law, Street and Mountford, looking at whether or not a flat owner can exclude the landlord from the property. You'll see there's another post here on human rights. So it's thinking about how human rights law might apply to help those stuck in the situation of unsafe unsafe flats. And then some other posts look at perhaps remedies that might be available through particularly tort law and the Defective Premises Act. But the problem that overrides much of this in private law is limitation periods, that in order to bring an action you have to act within a certain period of time. Anyway, that's quite enough for now. I hope it's a taster of why I think ownership is a really important concept, and thank you for listening.